Hello, everyone. My name is Federico Tozzi. I'm the Executive Director of the Italy America Chamber of Commerce, and I would like to welcome every one of you, especially our panelists today, Frank Desiderio and Arthur Bodek from GDLSK. I've known Frank for many, many years. He was one of the first members I met when I moved to New York in 1997. His firm has been a member of the IACC for a long, long time. He's also been part of our, board and has been always a great supporter of the chamber. We are very lucky today because we have over 335 people. Um, some of them are based in New York, others are based in Italy. If you are connecting from Italy, you can switch channel. We have an interpretation service in place, so you can listen the entire webinar in Italian. I would like also to acknowledge a few of the organizations that help us also to have such a great attendance. The Banca Popolare di Sondrio, the Confabi, Assocamera Estero, our association in Italy, and of course, our panelists. GDLSK is the number one firm in tariff and trade in United States for 3 years in a row, according to 360 Law. Is a great partner of the IACC, and I believe that we're gonna hear from them today is going to be enlightening and will help all of us to make a better decision in terms of coming into this country. Without further ado, I'm going to give the floor to our panelists. The entire webinar is recorded, will be made available on our YouTube channel. At the end of the seminar, you can ask questions, and we will try to answer as many of those as we can. But if you have additional questions, when we send out to each of you the slides of the presentation, there will be a form. You can fill it up, and we will forward those additional questions to our panelists. Thank you again, and to you guys.
Thank you, Federico. Thank you for the gracious introduction. I'm Frank Desiderio, and I've been doing customs and trade law as all members of my firm have been doing for approximately 50 years. It's all we do, nothing outside of that scope. So we have been working hard on this for a long time. We've had a long history, and we've seen a lot of things come and go. And that's something that we'll be talking about today. Brief agenda is the history of the trade tariffs. Many people think that this trade issue is, something new. These trade wars have been going on for years and years. Historically, they don't hit page 9 of the Wall Street Journal, but it seems today it's on page 1 of every publication. My partner Arthur will talk about the trade actions that were implemented under Trump 1, some of the proposals that have been announced under Trump 2. He'll talk a little bit about what the implementation will look like, and then we'll also talk about strategies that should be considered to kind of reduce our liability or give us some buffer to avoid the entire pain of any tariffs that are actually approved. So let's go to the second page on the presentation. So there have been 3 or 4 or more major trade wars. First of all, anti-dumping, which I'm not going to talk about very much, or countervailing duty. These are provisions that allow the United States to impose retaliatory duties where foreign governments or manufacturers not following the rules of trade. So that's been going on since the first statute, I think, was 1914. So there have been many trade actions in connection with those particular provisions of law. We represent a lot of the foreign manufacturers who have been called as respondents in those cases. So that's kind of a general overview of the history of anti-dumping and CVD. And they've been imposed and used under virtually every American presidential administration since I've been practicing law. just a couple of interesting taxes that were imposed over the years. And the first one that I guess I knew about when I started was the chicken tax. In 1964, LBJ imposed a 25% tariff on light trucks in response to tariffs and quotas placed on American chickens by France, West Germany, and other and other EU countries. The result was a retaliatory tariff of 25% on light trucks. That tariff is still in place. There have been some discussions within the Trump administration about adding products to that retaliatory program. That's only speculation. Before I go any further, I just want to make one point. What we're going to talk about today is what's happening, what can happen, how it's happened in the past, and talk about different types of strategies. Nothing we say here today is political. I'm not going to tell you this is a good idea. It's a program that's going to work. It's a program that's going to fail. We're just going to talk about the reality. Another major trade war that we've encountered is the banana war. So in 1993, the European Union started giving preference to bananas that were originating in their former colonies, Africa, the Caribbean, the Pacific, and so on, to the detriment of the Latin American countries that America had interests in. So companies like Chiquita and Dole suffered as a result of that. In response to that, U.S. imposed tariffs on pecorino cheese, cashmere sweaters, different product categories. The practice has been challenged, and U.S. went to the WTO, World Trade Organization, and won. And even decades after legal battles, in 2009, the EU reduced the tariffs, and the dispute was settled until 2012. So you can see that these initiatives can last for a very long time, even after front page discussions end. The Byrd Amendment is a kind of a famous amendment that was designed to distribute anti-dumping duties and countervailing duties collected in connection with offending countries and manufacturers, and to distribute them to the American industry sectors that were suffering as a result of those practices. Essentially, a lot of money was collected, very, very little found its way to American petitioners. Most of it was kept by the government, surprise, surprise, in an effort to use those monies to beef up their trade enforcement policies and practices. In 2005, the Byrd Amendment was repealed, so that's no longer an issue. One of the more interesting ones that I think is the beef hormone war. In 1989, the EU banned the import of beef treated with growth hormones from any country. The U.S. and other countries went into the World Trade Organization to contest that decision. The World Trade Organization found that there was no evidence that would cause anyone to properly believe that growth hormones were detrimental to American consumers. But notwithstanding that fact, there have been discussions, debates for many years. It wasn't until 2009 when the EU relaxed the regulations, and they do allow some beef with some types of hormones, but no beef with growth hormones. So that's the concession that EU made caused U.S. to suspend tariffs, which were about 100% on various food products from various European nations. But the fact of the matter is the EU still continues to ban beef hormone importations. So having said that, that's a brief history of a few of the many, many wars that have gone on over the years. And I'd like to turn the program over to my partner, Arthur Bodek, to talk about trade actions imposed under Trump 1 and some of the possibilities under Trump 2. Arthur?
Thank you, Frank. By way of introduction, as I'm sure you've all figured out, I'm Arthur Bodek. I'm a partner of Frank Desiderio. Unlike him, who has been doing this for approximately 50 years, I'm the new kid on the block. I've only been doing it for 38 years. Let me join Frank in thanking the Chamber for this invitation and all the hard work in putting this together. And as you know, a theme of Frank's comments was a recurring theme was that none of this is new. That there have been trade wars going all the way back. Maybe it's kind of intensified. I should take back the maybe. It has intensified under the current administration. But it's not new. And let's get into some specifics. Under Trump 1.0, the big additional tariff that was added by then President Trump was what we all know and lovingly refer to as the China 301 duties. So that was intended to address a situation where the U.S. maintained that China was stealing intellectual property by means of forced technology transfer and practices, where if there were joint ventures and whatnot, that there were forced U.S. companies were forced to transfer technologies to China. So to remedy that, the U.S. Conducted an investigation, documented the practices that it deemed to be unfair, and then a recommendation was made by the USTR, the United States Trade Representative, to the president to implement tariffs. And the way it was implemented was on a rolling basis. So the initial action was tariffs against a preliminary list of $34 billion worth of Chinese imports. And that covered generally machinery, industrial goods, big heavy duty items. And the goal, the hope, was that would bring China to the table to resolve the alleged infractions, and that everything would be resolved as a result of that. That did not happen. So the U.S. then rolled out a second list, known as List 2 or Tranche 2, of an additional $16 billion worth of goods. And that included some more industrial items, chemicals, plastics, motorcycles, electronics, and semiconductors. And as was the case with List 1, the U.S. assessed an additional tariff of 25% against items falling within the tariff provisions covered by that list. And the hope, again, was that China would come to the table, would address the allegations of the United States, and once an agreement was reached, the whole thing would blow over. As we know, that did not happen. So then there was a third list that was rolled out, covering an additional $200 billion worth of Chinese imports. And now, by virtue of the larger list and the nature of the products, it began to hit, not just big businesses, but consumers. It included such consumer goods as furniture, electronics, seafood, luggage, fabrics, and it began to touch the clothing realm, although that was more impacted in List 4. Now, interestingly, when List 3 was initially rolled out, it was rolled out at 10%, as distinguished from List 1 and 2, which were rolled out at 25%. List 3 was rolled out at 10%, again, with the hope that that would bring China to the table, resolve the allegations, and all would move on. There was insufficient movement there, so that 10% for list 3 was then raised to 25%, as was the case with lists 1 and 2. So, as you can see by the dates, there was negotiation behind the scenes to try to contain this matter, but they were unsuccessful. So in September of 2019, there was a list 4 which was put forward, and that covered $300 million worth of Chinese imports, again, very heavily impacting consumer goods, a lot of clothing, footwear, consumer electronics, school supplies, toys, etc. And that also was rolled out in a measured way, that list 4 was split up into lists 4A and 4B, with the notion that 4A would be implemented immediately and 4B would be held out there. And list 4A originally was rolled out at 15%, an additional 15% tariff. And there was some movement forward, which resulted in the Trump 1.0 administration reducing that tariff from 15% to 7.5%, which is where it holds now. And agreement was also reached to suspend list 4B. So anything on list 4B never became subject to the China 301 tariffs under the Trump 1.0 tariff regime. And all of that was further to what you'll sometimes see referred to in the press as the Phase 1 agreement, where China agreed to take certain steps. And one of the actions of the new Trump administration, not to jump ahead, is to re-examine the compliance with that Phase 1 agreement to decide what, if any, action to take with respect to that.
Arthur, if I can interrupt just for a second, all of these programs, all 4 lists, were the subject of hearings down in Washington. So we met with panels of staff from the Department of Commerce, Department of Labor, the Special Trade Representative's Office, Treasury, and so on. And they actually didn't want to hear from lawyers. They wanted to hear from people in the business sector. So we spent a lot of time helping clients prepare their presentations. But this is not done in a vacuum. The response is to the fact that China acceded to the World Trade Institute organization 50 years ago, and in doing so made a lot of commitments to comply with intellectual property protection, fair access to the court systems, prevention of counterfeit and drugs and things of that and so on. And apparently, notwithstanding all the promises to keep, we're going to do it, we're going to work on it, and so on, virtually every administration had discussions with China, which were unsuccessful. And that's where we find ourselves now with Trump, who seems not to be willing to wait any longer for some of those changes. I'm sorry.
No, good. Let me piggyback on that excellent point, that under the China 301 measures under the first Trump administration, there was a whole administrative process before the additional tariffs hit. So, there were comments that were solicited from the public. Should we do this? How high a tariff? What items, etc.? And then as each list matured, there would be a proposed list, and the public would be given an opportunity to comment on the proposed list. And we've had a number of successes where we'd say, not to put anyone in the limelight, but we'd say, item 1, 2, 3, 4, 5. That's critical to the U.S. economy. There's no intellectual property. It doesn't further China's attempts to corner the market, and it really would be counterproductive. So it should be dropped from the list. So, we've had, as I said, a number of successes in getting items dropped from the lists. And in addition, there were, for specified windows of time, there was an opportunity to ask for exclusions where, to ad lib, if one of the items on the list was widgets, and we had a client that made green widgets, and they were able to demonstrate that green widgets are only made in China, and they're critical to the U.S. economy, et cetera, et cetera. We were successful in getting many such exclusions, even after the list went into place. So, the tariff provision covering widgets would still apply, but there would be an exclusion, in my example, for green widgets, because a demonstration was made that green widgets are critical to U.S. infrastructure and economic interests, and don't further the intended purposes of the China 301 countermeasure. So what's really gotten the lion's share of attention under the Trump 1.0 administration were these China 301 tariffs, because they were so pervasive. They covered, I'm ad-libbing, 80-90% of the tariff schedule, and they covered, so much in terms of import volume in dollars. Not surprisingly, because China is such a significant manufacturing country. But it's noteworthy that there were a number of other actions that were also brought under the Trump 1.0 administration. The first was a Section 301 case, again using the same tariff measure, which is there to remedy or counter unfair trade practices involving EU large civil aircrafts, where the allegation was that the EU was unfairly, in the eyes of the United States, subsidizing Airbus to the detriment of Boeing, and creating an unbalanced trade equation. So that was initiated back in 2019. There were targeted tariffs against selected products of specified EU member states. The EU retaliated and assessed tariffs against some, very prominent U.S. items, for example, denim jeans. And the two countries, they came to an agreement of sorts where there was some movement forward, but it was not concluded. It was simply suspended and kicked down the road for 5 years. So while this is somewhat of a sleeper issue, people have not really been talking about it, that there's a snapback provision that, unless resolved, these tariffs come back in 2026. So stay tuned on that one. The next one was several Section 301 cases brought by the U.S. with respect to digital services taxes in 11 different jurisdictions, a whole number of EU countries, as well as some other countries. The U.S. allegation was that taxes on digital services put the U.S. at a disadvantage, and therefore the case was initiated. It actually went all the way through to tariffs being announced, but there were agreements reached in terms of canceling or modifying the local digital service tax regimes, and that action was suspended. So, that's off the table for the moment, but it provides some insight as to what may come back under the current administration. Another very big one is the Section 232 action, which brought tariffs on steel and aluminum products, well, steel and aluminum mill products, and then a short list of derivative products, like nails and and other fasteners and other such similar items, a rather modest list. And that action, Section 32, is basically a national security statute. So the United States did a whole study on how the production of steel overseas and the volume of imports into the United States was such that it created a national security risk. And therefore, and then again, an investigation was done. Facts and figures were unearthed and brought forward, and the action that was taken was tariffs of 25% against steel mill products and certain derivatives, and 10% with respect to aluminum. And after some back and forth, certain countries were exempted outright, for example, Mexico and Canada. And then certain countries were exempted because an alternate regime, basically a quota arrangement, was reached, for example, with Korea, so that they were not subject to the Section 232 tariffs, provided that they kept within the agreed upon quota. And there was an exclusion process there as well, where it was not exactly the same, but similar considerations, where if one could show that, a particular type of steel was only available in China, that the U.S. importer tried to source it elsewhere, but couldn't find it, and it really had to be an unavailability standard, not it's more expensive standard. And if we could also show that it was critical to national security, for example, we had cases where certain steel mill products were critical to the fiber optics industry in terms of protecting underground cables so that we could all have internet and cable in our homes, etc. That would make a compelling case to sustain the request for an exclusion. And it was a whole protracted process that a company could object. They could say, hey, I'm here in the U.S. I make that steel that has been the subject of an exclusion request. And then there was a rebuttal where the requester could say, no, you don't, or your steel is not as good as the steel that we need for this purpose. And then there was even a surrebuttal process. And that whole Section 232 regime with the 25% and 10% tariffs remains in place, although there have been further developments, which we will get to momentarily, under the actions taken by Trump 2.0. So here are the current, I put proposals in quotes, because if we've learned anything from the Trump administration, particularly Trump 2.0, he's not very big into proposals. He's more into edicts, more into saying this is what will happen, not this is what we suggest will happen. So just to run through them, the first was with respect to Colombia, where the U.S. is in the process of firming up its immigration system, particularly with respect to people in the United States illegally, and there's been an uptick of deportations, and there was a flight of immigrants from Colombia that were returned back to Colombia, and the president of Colombia would not accept them um, for various reasons. His concerns were they were brought in on a military plane, like prisoners, and he said, we're not accepting them. So Trump said, all right, well, we're going to assess 25% tariffs on all goods of Colombia this week. And if you don't agree to start repatriating your citizens, it'll be 50% next week. Within something like 12 hours, the president of Colombia sent his personal plane, which allowed him to save face because it was a much nicer plane than a U.S. Military cargo plane. And an agreement was reached, and those tariffs immediately went away. Then the next one, which is a pretty big deal, is with respect to China. In addition to existing tariffs, the president assessed 10% additional tariffs on all goods from China. There were certain really irrelevant non-commercial exceptions for charitable donations, informational materials, but from a commercial perspective, with respect to all goods from China, um, premised on or supported by a desire to get China to step up and do its role in the stop of the flow of illicit drugs, particularly fentanyl and its chemical precursors. And that took effect, so it's already in effect on February 4th of this year, so just a number of days ago. And one aspect that that kind of took people by surprise is that it also included Hong Kong. So it includes mainland China as well as Hong Kong, unlike the earlier, still in effect, China 301 duties, which are only with respect to mainland China, not Hong Kong. And then what the executive order also provided for was that the de minimis program, which I'll elaborate on in a moment, was to end with respect to China. And what the de minimis program is, just like when a traveler returns to the United States, there's an exemption of $800. If you go to Italy and buy a suit, a scarf, or what have you, pair of shoes, you're entitled to an $800 exemption from tariffs when returning to the United States. That same exemption applies on a commercial basis. So, if Frank or I, as consumers, we order something online, if properly structured, the e-commerce supplier can send us an item that's less than $800 measured per consignee per day without having to pay duties. So, that was a very lucrative program, heavily used by China. It was also a very big deal, for goods made in other countries as well. There was a whole business model where companies set up distribution centers just outside the United States and Canada and Mexico to be able to get that duty exemption, which wouldn't apply if commercial quantities were sent all together, to a distribution center in the United States. So the de minimis program under the executive order was killed. However, it was brought back to life a few days later because the government discovered that CBP, our customs service, did not have in place a mechanism where they could just flip a switch and make it go away. They have to develop systems in order to stop that processing and to convert it to traditional commercial processing. So once an announcement is made that those processes are back in place, the de minimis will end. Continuing down with the Trump 2.0 proposals, let me jump out of order to Mexico, the last one on the slide that I'm sharing. So the threat there was an executive order threatening 25% tariffs on all goods of Mexico. And that was motivated by an accusation or a position that Mexico was not adequately controlling its border, both with respect to immigration issues as well as the flow of illicit drugs. And no sooner did that executive order get issued that there were talks between the presidents of Mexico and the United States, in which Mexico made all kinds of promises, including sending 10,000 troops to their northern border, our southern border, in order to try to rein things in and to renormalize the situation. And as a result, the United States stopped or suspended for 30 days its plan to impose those 25% tariffs. And there's a pause, which is currently in effect through March 4th of 2025. So we've got a couple of weeks left on that pause. Now, similar story with respect to Canada. There was an executive order threatening to assess 25% duties, the same concerns that exist on the Mexican border also exist on the Canadian border, although not to the same degree. And there, it actually, there was no, unlike Mexico, which picked up the phone immediately, Canada did not. So that actually went all the way to a customs directive being issued as to how the duties were to be calculated and collected. And at that point, the Prime Minister of Canada picked up the phone and a deal was reached there too, to pause for 30 days the 25% tariffs to allow Canada, in this case, to do what it needs to do to rectify the situation. And let me just add that although both of those are under pause, the language is such that if the U.S. determines that either country is not doing what it promised to do, or if the situation gets even worse, then essentially there's a snapback provision that these tariffs could hit, tomorrow if such a determination were made. But the default is that these are suspended through March 4th. A few more. The Trump administration has been very busy in its first month. And, one point that Frank and I were discussing just yesterday is that, perhaps distinguished from Trump 1.0, Trump 2.0 came in very well prepared. That if you read these notices, they're very legalistic, they're full of citations, they are full of history and previous findings, and they're really designed to make the case and to hold up in court. And the fact that these were dropped, so many of them, so quickly, we feel, Frank and I, is a testament to the fact that he and his team, that he's surrounded by trade wonks, who speak the trade lingo and know the legalese in the trade area. We suspect that these were teed up and written, before Trump was even inaugurated, and that they were ready to drop once he said that, I'm ready, it's time to do so. So moving right along, the next big one, which was only recently announced, is with respect to steel. It's actually steel and aluminum, that the way it was drafted, effective March 12th, there are going to be steel tariffs of 25%, and the aluminum from 10% is going to be uplifted to 25. This bullet is already out of date. It says a waiting list of derivative products to be identified. Just a couple of days ago, there was a very extensive list of derivative products that were announced. And this is very detail laden, and in the interest of time, I'll just give highlights. But basically, with respect to the existing steel and aluminum 232 tariffs, all existing exclusions will seek to apply come March 12th. So if someone made the case that their steel should be excluded, that exclusion dies once either the quantity specified in the exclusion is saturated, or once March 12th hits us. And likewise, for countries having an alternative arrangement, such as Korea, Mexico, Canada, there too those duties will come back. And then on top of that, there's a whole list of additional derivative products, really a very extensive list of aluminum and steel products that which are not currently subject to Section 232 duties. Those will become subject once there's an announcement from the Secretary of Commerce that systems are in place to start collecting those duties. And we expect that that's going to have far-flung effects, because it doesn't just cover, tin mill products or nails, but it, can cover all kinds of commodities, both industrial and commercial, that are aluminum or steel products, or if covered by the specified tariff headings, contain aluminum or steel. So, we think that is, assuming it comes into effect and there are no last minute reprieves, that's going to have very far-flung effects. The latest one that was announced, there was a presidential document dealing with reciprocal tariffs. So one of the driving considerations of the Trump administration is that the trade picture, the field vis-a-vis the United States and the rest of the world is unbalanced. That at the risk of oversimplifying, the U.S. has low duties, many other countries have high duties. So the Trump administration would like to level the playing field and either have the other countries come down or have the U.S. go up on a case-by-case basis. Now, there was an announcement just a few days ago, and we thought, that, all what was going to break loose. But the way the announcement came out, it was that there's going to be a study of specific situations, and once that study is done, then there will be follow-up action in terms of leveling the playing field. So right now we're at the study stage. So we fully expect this to come back at us, but it's unlike some of the other ones we mentioned. It's not imminent and not one we're living with. But when I say not imminent, we're talking weeks to months. We're not talking years. Then some others which really have been more talking points than have been actions. There's been a threat to apply universal tariffs, just an additional 10 or 20%, because why not? There have been statements vis-a-vis the EU. A quote from a news item that I found. Trump had said the European Union is very, very bad to us because in his mind, there are all kinds of excessive tariffs as compared to that are being assessed by Europe that are not being assessed by the US. There hasn't been anything tangible there yet, but stay tuned. And a lot of these other tariffs that we talked about, for example, steel, that will affect the EU. Right now there's a quota regime on steel from the EU. And then for good measure, the president has made comments about adding additional tariffs to the BRICS countries, Denmark for having the audacity to wish to retain Greenland, and Panama for the audacity of seeking to retain the Panama Canal or not allowing U.S. ships to pass through without the payment of tariffs. So let's take a couple of minutes to talk about, the statutory provisions and what implementation looks like. So we have the
Arthur,
one.
can I interrupt you just
Of
for
course,
one moment?
of course.
Yeah, Arthur alluded to this, and I think it bears some comment. These presidential proclamations have been really well thought out and well written. Now, I'm sure that once our lawyers look at them more carefully, we'll punch some holes in them and we'll have some opportunity to attack the implementation under these proposals to the extent that they don't meet the law, they don't articulate the right types of things. They put a lot of work into this. Again, as Arthur said, I think that these proclamations have been well written and designed to anticipate litigation and to and put themselves in the strongest position to defend against that. Just going back to the 301, and we're very much involved in litigating that case. At some point in time, when Trump rolled out list 3 and 4, we believe that he did not do it in a timely fashion. So he has an opportunity to do certain things within the time frame, and we think he exceeded the time frame with respect to those two lists. So that's under contest. Right now it's in the Court of Appeals for the Federal Circuit. We are also claiming that the provision of law under which he added list 3 and 4 were provisions that allowed for the modification of prior tariffs, not the enormous expansion that he did. So those are two arguments that we've raised. There are several other law firms who are involved in this case. We're collaborating. We have about 4,000 importers that we represent in this case, and it will ultimately wind up in the Supreme Court. And what the result will be is anybody's guess. But my only point here is there are opportunities to contest some of these decisions, whether it is a denial of an exclusion or an exemption, or whether it's a failure to extend or revocation. There may be opportunities to undo some of the damage if they haven't dotted all their I's and crossed all their T's. And so with that, I'll go back to Arthur, and he'll talk about the way these laws are implemented.
Thank you, Frank. So the 301, which is the big one under the first Trump administration, the China 301 action. So that is intended to address unfair trade practices like the forced transfer of technology or allegations of unfair subsidies. And there are certain set out timeframes. The USTR is to do an investigation, finding whether those actions actually occur, the extent of the harm, and then to make recommendations to the president. And as Frank mentioned, there are particular time frames within which action on that report and recommendations must be taken. And what underlies our court challenges of the China 301 actions is that the lists 1 and 2 were imposed within the time frame specified in the statute, but lists 3 and 4 were implemented afterwards, after the time frame contemplated by the statute. And so the issue is, was that a new action, therefore untimely, or was it a modification and therefore timely? And then, as we saw from the numbers, the first 2 lists were relatively modest in terms of the dollar volume. It was like in the 16 million, billion, 34 billion, and then then the next one was like 200 billion. So there's arguments back and forth whether such a huge expansion is merely a modification or whether it goes beyond what the statute allows. And then, as I alluded to before, so I won't belabor the point, there were proposed lists with opportunity for comment, and then there was an item-specific exclusion process. So unlike 301, which is an unfair trade practice statute, we have Section 232, which is a national security statute, and that underlies the steel actions, where the assertion is, with so many other countries having control of the production of the steel that the United States uses, and steel being such a important commodity from the perspective of national defense, that triggers Section 232. And again, there's an investigation with findings submitted to the president. We don't have the same administrative process as we have in the 301, and there was a party-specific exclusion process, and there are many exclusions out there, but they will all expire by March 12th. And then with respect to the new tariffs, particularly with respect to those that were imposed on China, now to include Hong Kong, and that are threatened but suspended with respect to Mexico and Canada, those were implemented under the, I always have to look up what this stands for, the International Emergency Economic Powers Act, or as others refer to it as the IEPA. We have a lot of acronyms in our practice. So there, the president declares an emergency and then can implement tariffs immediately. So the president, again, going back to laying the foundation and drafting these notices very well, the president declared a state of emergency with respect to the border, which then gave him the foundation to rely on that declaration to immediately implement the tariffs, and they remain in effect, and they do not need additional congressional approval. And historically, these have often been challenged for overreach, often upheld because of the president's broad discretion with respect to his exercise of national emergency powers, but Congress can weigh in to seek to terminate them. So that's kind of been the go-to statute, not for the steel and aluminum, but for the tariffs that drop immediately. The IEPA has been the go-to statute because there just has to be a finding of a national emergency, and then the tariffs can immediately drop.
And
so
I'd just like to add something on that. You'd be surprised about the long list of products that are considered sensitive to national security. Certainly, weaponry, certainly metal materials, but even fabric has been subject to extra tariffs as a result of this, because we need textiles to make uniforms, to make tents, to make parachutes, and so on. So, you know, the possibilities here are very broad, and we shouldn't consider it something that would only apply to war materials that would put us in a detrimental position in any conflict.
Yeah, and Frank and I have been doing this long enough that, we grew up in our careers with quotas on clothing from many different countries, and one of the considerations was national security. And clothing, textiles always seems to draw outsized attention. Any free trade agreement, there's a textile chapter. When there are quotas, they're on textiles. If there are rules of origin, there are special rules of origin for textiles. So, there's always been an outsized emphasis on, the role of textiles in the economy and national security. So, it should surprise no one if we start seeing textiles being, drawing the attention of additional tariffs. I had someone once comment to me, that, it's easier to import, material for a nuclear bomb, sometimes than it is to import textiles in terms of regulations. That's not necessarily my legal opinion, but that was the venting opinion of a client of ours in the textile industry. Anyway, we provided you with this tight little slide, which we don't expect you to read on screen, which gives the highlights of the three main tariffs that are being used now, and the triggers and the duration, etc. This will be downloaded. Consider this as our parting gift. It's a good reference tool in terms of what the administration can do. So I'm going to turn things back to Frank on the topic of, it's all been, gloom and doom until now. These tariffs are coming, in many cases have already arrived. Well, what can we do about it? Is there any workarounds or any solutions? And with that, let me pass the baton back to Frank to address that topic.
Thank you, Arthur. So all of these lists that provide the list of items that are being affected by specific tariffs, all are based upon specific provisions of the Harmonized Tariff Schedule of the United States. So we find ourselves in many instances in situations where certain provisions are in and certain provisions are out. So obviously we make an effort to find an opportunity to identify a provision that we can squeeze our product into legally and avoid the tariffs. And one example that I have here is with respect to gaiters. I have a picture of it because I'm not sure of if everybody knows what gaiters are, but these are the kind of cloth scarves that you pull up over your face, you pull up over your nose, and you can even pull up over your head if you want to use them. Customs classified that product as hats under 650.05. The duty rate was 20 cents per unit plus 7% plus the 25% China tariffs. Now that pretty much could put the company out of business. I mean, it's a low cost item, so margins are not that rich. So we went out and looked for a different possibility. And I came up with the idea that they were really more akin to shawls, scarves, and mufflers. And the duty rate was under a different provision at 11.3%, but no 301 duties. So while we raised the tariff from 7% to 11.5%, we recouped much of it as a result of the reversal of the 25% application. So essentially, we saved the client 20%. And we did that through the administrative process. We filed claims, and they were resolved administratively. In other situations, we have to actually have to go to court, and that's a long, drawn out, and more expensive proceeding. So we like to strike as early on as we can. The one important observation I would make here is that our presentations are legal briefs. This initial action was precipitated by an importer having his import manager simply write for a ruling saying, here it is, how do you classify it? And of course, they came out with a negative ruling, and I had to undo that, get it reversed, and get it into a different provision. So these are things that people should be thinking about at this point in time, even though, the playing field is still not clear. So that's changing the classification. And we did that years ago, and we were very much involved with the Italy America Chamber in doing it. As a result of, I might have been the beef hormone or one of the other trade wars, they imposed 100% duty on canned tomatoes. So they were being assessed with 100% duty. So even a small importer who was importing $3 or $4 million was paying $3 or $4 million in duties. And after analyzing the contents of these canned tomatoes, and sometimes perhaps manipulating the contents by adding some olive oil and some oregano and some other spice, we were able to move that product into a provision for sauce preparations. And the sauce preparations provision was not covered by the retaliatory duty. So those are reclassifications, and we do that all the time, and we very often overturn customs headquarters rulings on the subject. But again, it's an arduous process. It involves a deep analytical approach, legal precedent, and significant briefs. The other issue is condition is imported. Very often, the condition of import will change the ultimate outcome. So I'm giving you an example here that we came up with, which is the split air conditioning units. I'm sure you've seen them in restaurants and stores and so on, and homes, where you have an exterior compressor and then you have a inside air blower that circulates the air internally. It's a relatively inexpensive way of air conditioning space, unless the house is being totally retrofitted. So when they rolled out the provision for air conditionings, when they rolled out list 1, I believe, it included air conditioning units, but what it didn't include is parts of air conditioning units. So we were able to avoid the duty on the entire product by directing our client to ship the top portions on one vessel and the bottom portions on another. And when they cleared customs, they came in as parts instead of finished air conditioning units. And as a result, they avoided the 25% duty. I think another issue, another approach to this is perhaps developing a strategy where the country of origin can be changed, where a particular country is the subject of a particular tariff. Country of origin is a significant factor. So there are situations where components are manufactured in China and shipped to Vietnam for certain types of assembly. And unless they established a substantial transformation, even though the finished product comes out of Vietnam, customs would view the country of origin China and therefore subject to duties. So I'll let Arthur talk about a case he worked on relating wine preservation units.
Thank you, Frank. So the standard, so every item imported into the United States has a country of origin. And, we live in a world where, unless you're talking about, a fruit picked off a tree, or a fish caught in the water, things are processed in multiple countries. So every item that comes into the United States legally has a country of origin. So the standard that has been used in trade remedy cases historically, although it remains to be seen, how things will play out going forward under some of the new tariffs, has been the standard known as substantial transformation, where something is processed in a second country such that it becomes a new article with a new name, character, or use. So before I talk about this example, just to kind of give another one which addresses both ends of the spectrum, there are a couple of rulings out there issued by customs of motors that were assembled in Mexico from Chinese inputs. So in one case, there were three sections of a motor, three subassemblies from China that were sent to Mexico. They were assembled together to make a motor, and customs held it was still considered a product of China for purposes of China 301, because these components were dedicated, these subassemblies were dedicated to be used to make a motor. There was nothing else you could do with them. It wasn't a horribly complex assembly in Mexico, so they were assessed the China 301 tariffs. At the other end of the spectrum, there was another motor ruling where there was an assembly of a motor in Mexico, but more at the basic componentry stage, hardware and whatnot. And there, customs held that the hardware and early input parts were substantially transformed from hardware to a motor, and they were not subject to the China 301 tariffs. They were a product of Mexico. So with that background in mind, I thought kind of an interesting case that we worked on. There is a company that makes a wine preservation system. And this ruling you could find on the internet. It's all public knowledge, where basically, as probably all of us know, if you open a bottle of wine and you only drink half of it and you put it in the refrigerator, in a short amount of time it's going to oxidize and go bad. So this product, it clamps onto a wine bottle and it pumps in argon gas, which displaces the oxygen. And the argon gas is non-toxic, it's inert, it's perfectly fine. And because it displaces the oxygen, the half empty, half full bottle of wine will last much longer because it won't oxidize because there's no oxygen. So that being said, the product had been made in China, and then there were production steps that were being shifted to Indonesia, and we were working with the client to find the right balance of what do we need to do in Indonesia to make it a product of Indonesia such that it would not be subject to the China 301 tariffs. And in addition to working with the client, we had meetings with CBP officials. And to cut to the chase, what this turned on was the assembly in Indonesia was not considered to be sufficiently complex, but there was one component known as the valve assembly, which was made in Indonesia, which was considered to be the essence of the system, the heart and soul of the system. And because that was made in Indonesia, that tipped the scales in favor of the country of origin being in Indonesia, even though there was a fair amount of China input. So this is the country of origin play. Some refer to it as origin engineering a product to take it outside of the scope of a particular origin-based punitive tariff. There are other strategies, and at this point, I'll pass the baton back to Frank.
Okay, just to add another point to Arthur's comments, when we talk about country of origin engineering, that may mean that we have to change our processing a little bit, maybe do a little bit more in one jurisdiction and a little less in another jurisdiction, or maybe it may be required to source certain parts in one jurisdiction as opposed to the other. These are all very, very subjective decisions on the part of customs. And again, I think Arthur alluded to this, we do it in a very transparent way. We would not give our client the recommendation to do A, B, or C unless we vetted it with customs and sometimes obtained a customs ruling in advance. So all of the things we're talking about today in terms of strategies, we do in a transparent fashion. We always dig down, get the best facts we have, make the best arguments we can. We present them to customs because you don't want to have a surprise 6 months or a year later if customs decides that the strategy we developed is not appropriate or we don't qualify for something. On that subject, there's another thing that we do a lot of, and that is modifying the basis of appraisement. All merchandise imported into the United States is imported probably based, 90% is based upon transaction value, which is the price paid or payable to the seller in the sale for export to the United States. And in 1992, there was a case where a Japanese trading company, Nisho Iwai, contested some decisions that were made by U.S. Customs. And ultimately, the decision came down is when you have a multiple tier flow, Customs is obligated to use the lowest valuation that qualifies as a sale for export to the United States. Now we refer to that as first sale. So very often you have a manufacturer selling to a middleman, selling to an American customer. And sometimes it's a 3 or 4 tier flow. And depending on how the documents are prepared, how the production is perfected, you may be able to go to an earlier stage than what we would call the first sale. So the following page is a chart that kind of lays out the strategy. So in a situation where a middleman is selling to its related importer for $1,000 and its cost of acquisition is $700, you can conceivably pay duty on the $700. In the European model, we've seen anywhere from 25 to 40% duty savings if it's done right. It's a complicated procedure. It needs to be presented to customs and so on. So the test is if you have an unrelated factory selling to a middleman, an unrelated middleman, that sale is by definition an arm's length transaction. It needs to be a bona fide sale. It needs to be a sale for export to the United States. And the relationship, well, there's no relationship, so that ends that question. The big issue is tracking the merchandise. If you want to put all your product in a warehouse and not segregate it by destination, that's a problem. Product has to be irrevocably destined for the United States. But we work with many companies that are employing this, especially in Europe, because the margins can be so great and because a lot of the fashion products that I work with are high duty rated products. So a handbag, a leather handbag is 20%. If you can save some value on that, it comes to be pretty big numbers. So we would basically argue that they're entitled to first sale appraisement and pay duty on substantially less than the middleman charge. And the reason for that is the middleman incurs a lot of non-production costs. They advertise, they sponsor races, they sponsor yacht competitions, and so on. And they develop the brand. They spend a lot of money developing the brand. And that is really non-industrial. We want to extract all non-industrial charges and wind up with an appraisement at the all-in industrial price that includes all materials, all labor, and related services. but not things like bookkeeping, accounting, real estate investment, advertising, and product development. So that's something that we've used very extensively since 1992, and our clients have generated a major benefit. And sometimes it's contested, and sometimes we have to go to the mats with customs to demonstrate that we qualify for the claim. But it's important that all the documents be prepared properly, that the documents are maintained in proper form, and that you qualify under the bona fide sale and are irrevocably destined for the United States. And sometimes we get involved with groups that need inventory management in their distribution centers. We don't do that, but there is software that does it. There are procedures that we're familiar with that enable an exporter to say, yes, when I bought this merchandise for my American customer, it was irrevocably destined for the United States. It cannot be diverted to other markets. Where first sale, for lots of different reasons, is not possible, where a middleman is not in place, you can insert a middleman and develop this strategy and develop this approach. That may not be viable for a particular company, but it's something that we do very frequently. And in all these situations, by the way, anything we're doing, we confer with tax and corporate counsel. The last thing in the world we want is to come up with a custom scheme or plan and win a victory in customs and cause a tax problem. So best results in all of these situations has been as a result of a legal team, a collaborative team. We only do one aspect of it. We only do customs, and we encourage our clients to explore these possibilities with their tax advisors, their corporate advisors, and of course, general management. Can this work in our product line, in our business sector? Is it manageable? Is it not? The other thing you can realize about this is there may be certain transactions that qualify first sale and certain other transactions that you're involved with that don't qualify. It's not all or nothing. So you can claim first sale on the transactions that qualify and pay the second sale duty in other situations that don't qualify. So, one way or another, in whole or in part, we can save a lot of money. Another possibility, not as productive, is where you don't have a situation where a middleman insertion is not possible, or where some of the inventory control is not possible. We help clients set up a buying agency arrangement. So on the next slide, buying agent services, is a list of buying agent services that historically have been viewed as non-production or oriented. So if a factory who's doing all the service inside of the factory, if they're willing to set up another company and treat it as a buying agent, those services or the cost of those services can be extracted from value. So in that situation, flip the slide to the flow chart, we would have all of the non-production related costs extracted from the factory, inserted in the buying agent, pay the buying agent's commission, pay the factory, the ex-factory industrial cost, and pay duty only on the ex-factory cost. So that's an alternative that has also worked successfully. Again, it's not as big a cost saving as the first sale, but depending on the scenario, it may very well be worth considering. And all of these things, again, that we're talking about, and there are other strategies as well that we haven't discussed, involve detailed analysis, review of the case law, written presentations, and vetting with customs and tax lawyers and corporate lawyers and anybody else who might have some impact as a result of the strategy that we've developed. Again, it's all transparent and it's documented and discussed with customs well in advance of the first importation. Having said that, I'll turn over the matter for other strategies to reduce adverse impact of tariffs.
So, thank you, Frank. Not a lot to say here. Product exclusions. So historically, under the Trump 1.0, China 301 tariffs, and the earlier steel and aluminum Section 232 tariffs, there was an opportunity for exclusions, and I can tell you under the China 301, because I'm the one who's been tracking it in the office, there are like over 2,000 of them, well, at its peak. Not all of them are in effect. And there's a very large number under 232 as well. However, while the last word has not yet been written, it's not, there is no indication that there will be exclusion opportunities under the new tariffs, but we'll certainly all stay tuned on that front. And then I'll turn it back to Frank for some concluding remarks.
Okay, just, my conclusion is I've dispensed several times in this presentation. Tariffs should not be considered fixed costs. There are strategies to reduce them. There are strategies to avoid them. And again, it's all done with transparency. And it will enable many companies to identify opportunities to reduce or eliminate oppressive tariffs. Customs planning shouldn't be done in a vacuum. Before implementation, firms should confer with their other advisors to make sure that we don't do something that runs afoul of the law that they manage. And usually when we're working with a team of lawyers outside of our expertise, we come up with the best results possible in all scenarios. That pretty much concludes our remarks. If we have time for questions, we'd be delighted to answer them. And if we don't have time to answer them, there's going to be, as Federico said, an opportunity to send those questions across, and we'll do our best to respond to them as quickly as possible. Cinzia?
Yes, I'm Francesca. Cinzia is also joining. Hi, no worries. Yes, if we have some questions, you can pop them in the chat. We have like around 10 minutes to answer some questions, so feel free to ask.
Either we were so perfectly clear, or people don't want to ask their questions publicly.
We've confused them. But just please understand that this is a first of possible other seminars. I mean, everything is in a state of flux. We can see things change dramatically from day to day. I am sure we'll have an opportunity to speak with you again in an Italy America Chamber of Commerce presentation and webinar. And we hope you've enjoyed this. We hope you've obtained some information of value to you. And again, if there are questions that you're trying to formulate.
Frank, I'm sorry to interrupt you. There's some questions. They're writing them in the Q&A box. I don't know if you can read it. Otherwise, I can read it for you.
If you'd be kind, let me just double check. I'll give it a shot.
And there's also Gina. She raised her hand. You should be able to talk, so feel free to open your mic.
For some reason, the chat is disabled on my end, but I wanted to ask if there have been any lawsuits filed yet regarding the newest implementation of these tariffs by any of the larger importers.
I'm not aware of any. I think it's too soon. Arthur, have you heard about any?
No, I think I read a piece about, some member of the public, bringing a suit, but in terms of, commercially viable cases, I haven't seen any either yet.
Thank you.
Francesca, if you could read some of the questions, because I'm not able to see
Yes, sure. So the first question is, what is status of the steel tariff on Turkey?
So I can take a stab at that. So Turkey has been kind of an interesting case. Under the existing 232 steel tariff, it was at 25%, and then Trump decided, due to whatever friction of the moment was going on, to raise it to 50%, and then that got resolved and it was brought back to 25%. But there are Turkey is certainly included in the the not yet applicable, but soon to be, we expect applicable steel tariffs. And I believe the proclamation has in there 50% for Turkey. But don't hold me to that. I'd want to go back and double check.
Okay, so another question is, regarding the revised Section 232, will it apply only to Europe or countries? If it includes countries like China, will it be in addition to the existing 25% tariff?
All countries, and yes.
Yes, and they're proposing for China duties up to 60%. So that and 232 duties would pretty much close them down.
So it's very interesting. So in a lot of cases, you have these layered tariffs where you have the regular tariffs, and then you have the, if we're talking about China, because that's such an easy example, you have the existing China 301 for many items at 25%, and then you have the new China plus Hong Kong tariffs at 10%. So now it's X plus 25 plus 10. And then, if it's covered by the steel or aluminum case, you may have another 25. So these are all layered, and these can add up very quickly.
I'd like to add one other thing as it relates to country of origin. A number of years ago, I worked with a company that was producing ladies' footwear in Brazil, and they were probably making 50 or 60 million pairs. And they decided to move their production to China. And when they did that, there was no technology there. There were no buildings. There were no footwear manufacturing machinery. There were no footwear engineers. And there were no roads, and there were very few inputs available in China. So that's changed quite a lot. And all of these factories are operating at full tilt. They are making the inputs. They're assembling the shoes and so on. My sense is that if anyone were trying to make a pair of ladies' dress shoes in any other part of the world, they would likely have a lot of Chinese inputs. And if you had all of the inputs from China and it was just an assembly in country two, I think customs would be looking carefully at whether or not that qualifies as a substantial transformation. But that's just one example of what's been happening as China has grown and its production capabilities of source materials and so on. So that's something that we really need to think about with our thinking caps on.
Okay, so I think we have like 1 minute to just answer one questions, and all the others can feel free to write your questions in the Google form. You should have access. I just sent in the chat the link. So the last question is, what is the capacity of customs to operationally implement all the measures? Any impact by the DOGE?
Well, there's obviously going to be an impact. I have a slightly different view. I think that 50% of the customs workforce could do 100% of the work if they all worked 8 hours a day. Now, that's probably unkind to a lot of good, hardworking customs officials that I've worked with over the years. But I think it will be a challenge, and it'll be a challenge for two reasons. One, there will be a shortage of staff. And the second reason is, even if there's not a shortage of staff, they will tell you that we can't get it done because we have a shortage of staff. I mean, we have cases pending in Washington for 4 or 5 years now, and that's totally unacceptable. We're certainly not alone. If anybody can get things pushed to the top of the food chain, we can, but it's become more and more difficult each day. With 100% of the workforce at customs working remotely, it's very difficult to reach people. It's very difficult to have meetings with people. I mean, throughout most of my career, I would go down to Washington 2 or 3 times a month. I'd fly down in the morning. I would have 3 meetings in the morning with customs officials, have lunch, go back, have 3 more meetings, and then be back on a plane at 5:30 to New York. That dynamic does not exist anymore. And if they're going to be able to get this done, I think they need to impose that kind of regimen or reimpose it. So it's only my guess. I think that there will be a slowdown because of the shortage of manpower, but hopefully that will be changed by having people work, at full tilt. That's my personal review. It's not political. It's just my experience over 50 years watching these agencies reduce their accountability and their production level.
Okay, thank you very much. Oh yes, go on, Arthur.
No, I was just going to say, I'll just very briefly add to that, whenever you have a new tariff with a particular scope, that always raises the specter of enforcement issues. Frank and I detailed some, tried and true, very legitimate, successful approaches we've had to work around some existing additional tariffs. At the same time, CBP is an enforcement agency, and if they believe that there are scenarios out there where people are contravening the tariffs, in a way that's not appropriate, I think we may be seeing an uptick in enforcement. So just throwing out that additional comment.
Okay, so thank you very much for this incredible presentation, and thank you all for attending this webinar. We are going to follow up with all of you, and we will send you the slides, and also you will find on our YouTube page the recording of today's webinar. So don't worry, you will have access to both the slides and the recording. So thank you very much, and yeah, that's it.